This is causating in 4031 Art plus Artisans Consulting versus Gerald Jones. Is that correct?
Yes, sir, that's correct. My name's Jennifer C.
C. Okay, my apologies. All right, ma'am. Just like the other case, I don't need all the specifics, but I need enough information because obviously you win. I just need to know the specifics of why there was a breach or what went on here that resulted in him owing you some money.
Sure. So we are a commercial art consulting business and we help our clients find artwork. So if lawyers are moving into a new space, for example, they would hire us to help outfit their offices with artwork. Gerald Jones is an artist. We've worked with him several times in the past, and we had a law firm that had worked with him in one of their offices and wanted to get another painting of his for their Houston location. We talked with him, we let him know, we have a signed contract stating that he would deliver a triptych, 3 pieces of artwork.
Are these like original pieces that are created?
Things. Correct. So we signed a contract. All the terms were stated specifically on how much he would be paid, including which was $9,432 for the artwork plus an additional $400 for delivery. So the total amount was $98.32.
And this is for work that you've paid him already for the artwork, but he never delivered it.
Correct. So we paid him a 50% deposit to get him started. And then right before the delivery date, we paid him the balance. And then we did not hear back from him. And 3 weeks go by. We're trying to get in touch with him. He tells us that he had a family emergency and that he can't make the original due date, but asked if it was an extension. Asked for an extension. And we reached out to the client to see if they would be willing to grant the extension because they're moving into these new offices, and they were willing to grant the extension. So they gave him about another 2 months to complete the paintings. And as we are getting closer, we're in contact to make sure that they're going to be delivered on time. The day before he was to install them, my project manager reached out to arrange the delivery, and he said he is not going to be able to complete the paintings and tells us that he is going to refund the money to us by the end of April. This was March of 2024. So the end of April comes, we do not receive the money. We're trying to communicate with him. We don't hear it. She is not hearing anything back from him. So then I am the CEO of the company. She reaches out to me, my project manager, Melissa, and says, he's not communicating with me. Will you please reach out to him? So I sent him a text and said, I realized that he had been in a difficult situation, but that he had told Melissa he would be able to refund the money, that I was willing to do a payment plan with him. And when, can he please answer me? I had sent him a long email and then I texted him. So
well, it seems like the easiest thing to do was him to just finish the paintings.
Yes, the easiest thing would be for him to finish the paintings.
I mean, you don't have to tell me anymore about the whole situation. Simply put, as you paid him for it, he didn't deliver. He had ample opportunity to still produce the paintings because he was given the extension and then given an extension to make payments and didn't do so, right?
That is correct.
Okay. All right. Anything else besides the $9,832?
I mean, a million hours that we put into trying to deal with this.
I get that, but you don't get that back, right? I mean, that's just the nature of these things. I'm just amazed that I don't know why I didn't think it, but that this business even exists. That you can go out there and contract somebody, an artist, to do these kinds of things. I'm sending you my daughter because she is the most amazing artist, not because I'm biased, but because she really is. Because
We
this is
find
what
many
she
of our
needs,
artists this
right?
way.
Yeah. So, okay, all right. I'm going to grant judgment in amount of $9,832. And, but one quick question. Why, if he lives in Houston, why'd you sue him here in Travis County? Why didn't you sue him in Houston?
I guess because I'm here in Travis County.
So for future reference, you need to sue him in Harris County because that's where he lives, right? And so that's where he can be found. Now, if he was served, and it appears that he was, it was up to him to claim that this is the wrong jurisdiction or wrong venue for him to be sued in. And so he's not here to say so. I'm just telling you that in the future, you need to sue the party where they can be found. I know that you're here and you've entered into the agreement here, but in fairness, that's what the law looks at, is where the defendant can be found.
I see. Okay, thank you for letting me know.
Oh. Okay, so just so that you know, I've just been informed that the affidavit of military status has not been filed, and we need to know that he's not been deployed, and therefore that's the reason he didn't answer. So you need to get that done. You cannot receive a judgment until that is complete.
Okay, yeah, we just found out about that. I know that he is not deployed because he posts regularly on his Instagram of all the other paintings that he's creating, except for mine.
You
But I
can,
understand. We just found out about that.
just file that, and then that'll just show proof and evidence that in fact, he's not in the military and therefore not deployed.
Okay.
And it's real easy. There's a government website that you do that. They'll give you the statement and then you just file it.
Okay, and so then after I file that, there was one more form that we just found out we were missing, so we'll get both those in this afternoon.
Was that the certificate of last known address? Yeah, there you go.
Yes.
Yeah.
So then.
So basically, that is just a statement from you stating this is the only address we have, or this is the last one we know that is valid for him. And so and then you file that.
So what happens now?
So you file those two things first. We send you a judgment, and then you can go ahead and file that judgment in Harris County or here. Okay. And then try to collect. That'll be the hard part. There are companies out there that will do, like kind of like trustees that will go out there and try and get that money for you. And generally those are attorneys that do that and try and collect. There are various ways, or you can try and collect. But when you file it here in Travis County, and then you can file it in Travis County, wherever he can be found. Basically, actually, you just need to file it in Texas is all you need to do. If he moves, let's say to Louisiana, you can then take it and file it there. You have to refile it every 10 years so that judgment stays alive. That in essence is a strike against him on his credit status and his credit report. And then you can continue trying to collect that. I can't tell you how to do it, but you can either hire an attorney to collect it.
So by filing it with the state, it's automatically filed with these credit agencies? I don't have.
What you're going to do is, what is it called? Abstract judgment is what you need to do, is need to file. And the abstract, that basically will keep that in place for 10 years or until it's paid. And then you have to renew it 10 years from now. So if he moves to a different state, you can go file it in that state as well.
But I don't have to file it with a credit agency.
No, that happens automatically. Yeah. So because the judgment will be there and the credit agencies will pick up the judgment.
Okay.
But if you want to collect it, you need to file that abstract so that it's good for 10 years.
Got it.
Right. And then if he moves out of state, you can take that abstract and file it. And then every 10 years, you can file it to renew it.
And do we file that with your court or do we file it somewhere else?
You file it here with this court. And you can call the clerks here. They'll give you a copy of the form. They just can't assist you with it. They'll just give you the form and you have to fill it out on your own.
Okay. Did you get that? Okay.
Okay. Is your address also in precinct 4? Because I thought I saw that your address is downtown.
We are on East 6th Street, east of I-35.
East of I-35, and 7th Street is the line between precinct 4 and 1. So you're okay. This is the correct. Yeah.
Okay.
Okay, not a problem. I just saw East Sixth Street. I didn't see the number or anything, so I didn't know if it was downtown or where it was. Are you right there, right on Sixth where World Liquor is?
We are on 6 and Purnell. It's like Favors.
Okay, that's further down then. Okay.
Okay, yeah.
I have a general idea. Okay, I not a problem. All right, anything else?
I think that is everything. We have so much beautiful documentation to submit to you.
Yes. Well, thank goodness for the court system that we create so much paperwork, right? That and lawyers, what we do.
Thank you very much for your time. I appreciate it.
Yeah, have a wonderful day and happy holidays.
Thank you, you too.
You too.
Bye-bye. Ending in 4037, Erlinda Garcia versus Leo Hernandez. All right, Ms. Garcia, you sued Mr. Hernandez because you paid him $1,400
Yes,
to do some repairs to your truck. Is that correct?
yes.
And what happened? He never did the work?
He never did the work and he never gave me my money back.
Okay.
And he
when-
stole some stuff off my truck.
Right. So this was in May 2021. When did you file this lawsuit?
Yeah. About, I think a year, a month ago, a couple of months or a year,
Yeah.
something like that.
Well, here's the crazy part. You are past the statute of limitations on this. You waited too long.
Well, they never called me.
Who's supposed to call you?
Well, I was waiting for somebody to call me to tell me when the court was going to be due or whatever.
No, the court has nothing to do with this. This is up to you to file it or not file it. And so you have, on a breach of contract, you have 4 years from the time that this happened to when you're supposed to file a claim against him.
Mm-hmm. Well, I filed it not too long ago, period, you know, because plus two, I
last
didn't have
year.
a way.
Okay. My
to go-
apologies, ma'am. My fault. I saw 1030 and I thought it was just last month or 2 months ago when you filed this, but you filed this a year ago.
Oh, okay.
So you're okay. My apologies. I didn't mean to scare you.
You did scare me.
Well, I'm sorry about that. I saw the date on there and I
It's
thought, well,
okay.
wait a second. But I was wrong. It's not the first time. It won't be the last, I'm sure. All right. So you paid
Okay.
$1,400, but you're suing for $2,053. What's the difference for it?
Because he ripped off a lot of stuff off my truck.
What did he take
He
off of
ripped,
the truck?
he ripped. Well, when my son went to go pick it up with a tow truck, I noticed that the spare wasn't there, the tire. It was brand new tire and some mats, floor mats, and some other stuff that he stole. I can't remember, but
And you're
I don't
saying
have my
that's
glasses,
worth
but
$653?
well, yeah, because of what he did, you know.
Well, but how do I know that it's worth $653? What do you have to show me or to prove to me that the spare tire, because what year was the vehicle?
2007.
So it's a 2007. Best case scenario, that tire is worth $50, maybe $100. Is that correct?
It was brand new, and the jack too, and
Well,
the floor
how much
mat.
is a jack? A jack, you can get them for $50.
Well, the jack was brand new. I never used it. You know, that's the thing. You know,
But how much did you pay for it?
it was with a truck.
It was with the truck. So it wasn't brand new.
Yes.
It was from 2007. You might not have used it, but it's still from 2007.
Yeah.
Right. And we're talking about in 2021. So we're talking about 14 years old. Also, the floor mats were the ones that came with the vehicle.
No, I bought those at the Walmart.
And how much did you pay for those?
Oh, I just can't remember, sir.
And what you said, spark plug wires. He took those right out of the truck?
Yes, spark plug wires. They cost probably about $40, $50.
Right. So how do you come up with $653?
Well, and then all the stress that he gave me that, he never fixed my truck,
Well, I
It
get
pissed
that,
me
but that's
off
the
that he never did
$1,400 that
nothing.
you paid him. I'm trying to
Mhm.
find out, how did you come up with $653 in the other damages? How did you come to that number?
I just did it.
Okay, well,
Mm-hmm.
unfortunately, you can't just make up things, right? You have to have some basis for that. Okay,
Yeah.
so what I'm gonna do here is I'm gonna just estimate because I don't have anything to go off of. Let's see.
Uh-huh.
I'm gonna give you $300 worth of credits for the other things that were missing. Because they are 14 years old. I don't know the value, obviously spark plug wires, you have to replace them, but so at 1,400 plus an additional 300, I'm gonna give you $1,700. Since
Okay.
you don't have anything to substantiate the value of the things that you're claiming.
Okay.
All right.
Okay. Yes, sir.
All right. So, anything else?
No, that's it, sir.
All right. He owes you the court costs as well, separate. Okay. So it's $1,700 plus the court costs. Okay.
Okay. Okay.
All right. Thank you, ma'am. Have a good day. We'll send it to you in the mail or
All
email.
right. Thanks. Okay. Thank you. All right.
Bye-bye.
Thank you.
Just because you win doesn't mean you actually get a judgment for a specified amount. For instance, you do have to still prove the measure of damages. What that means is, as an example, we had a lady who had a contract to fix her truck. It was $1,400. She paid, the work never got done. When she picked up the truck, there were some items missing, a jack, a tire, spare tire, things like that. And she just said, well, this is the value, didn't have anything to base it on, right? So you still have to establish what the damages are in order to get those. So we're going to begin with cause ending in 421. This is J4CV 25-000-421. Jarvis Riser versus Bob's Containers. All right. And so because there are no defendants here today, I don't need a whole lot from you. I'm not even going to swear you in because it's just each of you. We're not a court of record. But basically what I need to know is if there was a contract, let me know that there was a contract when you entered into it, what you were supposed to do or what they were supposed to do, what you paid them or what work you did for them, and that they didn't pay it or they didn't refund you your money, whatever it may be. And we can kind of move along. In other words, I don't need every specific detail of the case. I just need the basics to kind of establish that, in fact, you paid X amount or you were owed X amount and it either didn't get paid or the work didn't get done. Make sense? All right. So, Mr. Riser, you are first on at bat. You may proceed.
About 5 years ago, I decided to have a shipping container barbershop built out by Bob's Containers. That's how I met him. I was one of his first clients. Going forward, due to the pandemic and slowdown in work, it took him a while to finish that. And while he was doing that, we became friendly. As far as business, he noticed that I had a shop truck. I believe it was a 2010 F550. And he liked the truck. He wanted to use it for his yard, for work. And I was thinking about buying a new truck. So, I said, yeah, I'll sell it to you. We agreed on a price, and that's in the emails and evidence that I provided of $15,000. The contract that we entered into was through bill.com, where he was to send the money. So detailed everything out in the description. And like I said, since we were friendly, I didn't give him a formal paper contract or anything like that. I just wrote in the description the transaction we were doing. It was for $15,000. He paid me $5,000 through bill.com. And then after that, it was about 6 months of going back and forth in emails. Like I said, which I provided, where he would, say that the company is not doing well and, he can't afford it. I gave him ample opportunity to, pay me a lesser amount so we can kind of square the deal up, or we can, work it out in trade. But, he just broke communications after about 6 months. So now we're here. That was roughly about 2 years ago when he broke communication, and I decided to go ahead and, sue him in small claims court in order to recovered the $10,000.
And according to the complaint, there was also a 100-gallon tote that was along with the truck. Are you asking for a
Yes.
return of that as well? And what's the value of that?
That was, if I'm, like I said, this was about 5 years ago, all this stuff was done. But at that time, I believe I paid $300. Well, I paid $600 for two. So he kept one. I have the other one. So yeah, about $300 for that.
So 300 for that. All right. So I'm going to grant the judgment in the amount of $10,300. And I'll go ahead and send that out to you probably later today through email. Okay.
Okay. So I've never done this before.
Court, by the way, court costs are separate from the 10,300 that he also has to pay, but that's not the judgment itself. That's the extra portion. Okay.
Oh, okay. So like I said, I've never done this before. Just, I was reading that it said, even though I'm granted it, that, I don't know what happens after that. I mean, I know.
Yeah. Basically, he has, I mean, you can try and collect it, but if he has no money or if he doesn't have the vehicle, for you to go get the vehicle back, that kind of stuff, you're gonna have to file an abstract of judgment. You can get those forms here from the court. That basically means that it protects that judgment that you have here for the 10 years. And if he moves out of state, you can file that abstract in another state as well to try and collect from any personal property he may obtain. Every 10 years, you have to renew it. So you can keep this in perpetuity as long as you keep doing it every 10 years.
Okay. But it just, I mean, and I understand somewhat of what you're saying, and I have to do a little bit more research, but essentially, how do I get paid? I mean, do I literally go to?
You got to go collect it. I can't tell you how to do it. There are attorneys that's what they do for a living. There are collection agencies that do that for a living. You can hire them, or you can just, try and do it on your own.
I can literally go to his business and say, you owe me this. Here's my.
Well, you have a judgment. You can't just go walk in there and steal something off the shelves, right? I mean, you're going to have to go through the proper procedures. But that's basically, you can go to his business. You can put a lien on property through that abstract of judgment.
Okay. And do I have a officer or a constable or something come with me when I go?
Well, again, I can't tell you how to do it. Obviously, that would be a conflict of interest, but there are attorneys, there are collection agencies that do this for a living, this is their business to try and collect on judgments. You can even sell it to somebody else, and then that's what they do. And, they'll pay you 50 cents on the dollar or less. I don't know. But it's up to you to go collect that.
Okay. Well, I appreciate your time. Thank you, Jim.
You bet. What's that? Oh, we need a certificate of last known address. That's
Okay.
that you didn't do. So before we send you the judgment, you have to send that to us. Okay.
Okay. I'll do that. Do I just email you guys and let you guys know? Y'all automatically know I did that.
Yeah. You email it to us. There's a form on our website. You can just get the form from there, fill it out, sign it, and send it in.
Okay. Email the same that I emailed the evidence.
Same email address you just sent everything else to. Yes.
All right. Thank you.
Thank you, sir. Have a good day. You're suing Mr. Vianueva because you lent them some money. Is that correct?
Correct.
All right. So tell me a little bit about that.
Yeah, I lent him $8,000, and we signed a promissory note in front of a notary. Supposedly he was gonna pay back in a month. It's been over a year, and he never. I've reached out a couple of times, but he's never made one payment. So then that's why I went this route.
All right. How did you give him the money? In cash, a check? How did you pay it to him?
No, he has a business. So I gave him a credit card, and he ran it through his credit card machine. So that way I could, well, usually you don't pay interest if you pay it back in 30 days. And that was what we were trying to do.
Right.
For him to be able to use that money, but have 30 days to pay it back. And that way I didn't have to pay any interest or anything on that.
But you're charging him $150 of interest.
Right. That was the fee that
The credit card company charged you? Was that the interest they charged you because you didn't pay it on time?
well, no, they charged me more. I'm still paying. you know,
Well,
I don't know
So
where I
you
got the
don't,
hundred
so
and
your
fifty.
agreement with the credit card companies between you and him, I mean, between you and the credit card company, it's not with
Mhm.
him. So if he didn't pay you back, right, and if you don't
Mhm.
have a clause in your agreement for interest, then you can't collect on the interest. You can get post-judgment interest, right, after
Mhm.
today, but not for
Okay.
interest before the judgment, because that's not included in the, now you guys talked about, well, so that I don't have to pay interest, he's gonna pay back in 30 days. Right?
Mhm.
But there's
Mhm.
nothing in there that he's responsible for any interest payments that you're being charged.
Correct. I know where the 150 came from because I was supposed to get cash out from my card. And when I do that, it charges me a percentage. But then after talking, he said, oh, no, wait, I have a credit card on my business. We can just run it through. But we
Right.
had already drew up this contract. So yeah,
But
that's
the
where it came
cost to
from.
him is that he had to pay 2.5 or 3% interest on that 8,000, right? So when he charged
Yeah,
your $8,000 on your credit card, he didn't actually get 8,000. He got 2.5 or 3% less than that, right?
correct. You're right. Yes.
That was not contemplated in the agreement. He still charged the 8,000, so he's responsible for the 8,000, not any
Okay.
interest ahead. He is going to be
Okay.
subject to interest after today,
Okay.
right? So I'm going to grant judgment in the amount of $8,000.
Okay.
All right, and we'll send you the paperwork. Thank you much, ma'am. Good luck to
All
you.
right. Thank you. Bye-bye.
Next case on the docket, cause ending in 3417, Endurance Lift Solutions LLC versus West Oil LLC.
Good afternoon, Your Honor. In Exhibit B, you'll see an invoice. We sent out a rod string to the Mary Horn Unit Number 1 for West Oil right outside of Caldwell, Texas, to get the well back to producing in June of 24. West Oil was going to be set up as a new customer, and in the oil and gas industry, when to get the well back on, we do a credit app and all that fun stuff. He agreed to pay cash up front to get his well back on and producing, as oil was high at that time. From there, we sent out the invoice to John Upton and West Oil. We never received payment. We followed up with him multiple times. And then in December of 20, he said he was going to, December 20th of 2024, he said he was going to send payment and give us exact date on payment. After that, he has gone radio silence on us. We can't get a hold of him. Can't do any of that stuff. Any of that stuff is we can't get a hold of him at all. We did serve him. We did have his last known address in there. We do have the invoice as Exhibit B. And we are just trying to recoup our money for material goods that we've ran down hole for West Oil and John Upton.
I saw at one point that he had issued you a check, but it was returned unpaid. Is that correct?
That is correct. Yes, sir. It was returned that it bounced is the best way to put it.
All right, and it says here that the undue or the unpaid, the remaining due portion that's unpaid is $14,196.31. Is that correct?
That is correct. Yes, sir.
All right, then that'll be the judgment of the court. Thank you, sir. Good luck to you.
Thank you.
You bet. All right, next case on the docket, cause ending in 3873. This is Annette Kajar, executor of the estate of Andrew Damita Sr. versus John Heinz. And who's here on that case? I'm not sure if it's Kajar or just Jar, if the K is silent. Ma'am, if you'll unmute yourself and turn your camera on, please.
Did that help?
Well, I can hear you, but I can't see you.
Okay, I can see you, but let me see if I can figure out how to turn on. Oh, here it is. Can you see me now?
Yes, ma'am, sure can.
Okay, thank you. So it's Annette Care.
Say that again?
It's
Annette
pronounced Care.
Okay, my apologies.
That's okay.
And I see all kinds of spellings. Even my name gets misspelled all the time, or mispronounced, I should say. So I tried real hard.
I
But
appreciate it.
I've not been familiar with your name, so I wouldn't have known that one. Okay, so you entered into an agreement on behalf of the estate to do some remodeling repairs. Is this to a home in order to try and resell it that kind of thing, or?
It was a condo, yes.
Okay, so tell
to
me a little bit
resell.
about that.
Okay, so I hired, actually what John was an LLC, but his business, his LLC expired. And so I'm going straight, since that expired, I thought that the wall would no longer be applicable for him. So I'm going straight to him to file against him personally.
As a
And
general rule, what you do is you file against the LLC and against him personally.
okay,
You know, and then you sue them both in the same one, because he could file here saying that, look, I reinstated the company. And so that judgment against me personally is no longer valid, right? Because she entered into the agreement with the company. And he can renew that and he can correct it. And then your judgment isn't going to do much for you.
right.
But
Now, as
he's
of
not
today,
here to raise that as
yeah.
an issue.
Right. And the
Okay, so we
LLC is
can go
still
forward.
expired. Okay, perfect. But I'm happy to file another suit against the LLC. But in any case, I did enter contract with him on May 15th, and we were told at the time that it would be a 1 week, a solid week of renovating or fixing the items that needed to be fixed. There's about 21 items on that invoice that was submitted. Only 7 of those items were completed. I did pay him in full. He wanted payments in increments with the last payment with the walkthrough. And so he had promised me a walkthrough and if I could send the payment. So I did, but the walkthrough never happened.
So let me
And
ask you this. How much did you
Mhm.
actually pay him in full? Was it the 48.50?
yes.
All right. And how much of the work did he do?
Of those items, he completed 7 and
Out of the 21 line items?
yes, and on exhibit either A or E, it's your exhibit A or E. Each of those invoices have an individual amount. So I totaled that up at $1,935 plus $40 of a math error in my favor. So we add another 40 to that. Then I heard what you said about seeking judgment. I mean, the court costs, but I will wait on that. And you said it's on
Yeah, that's
automatically.
separate from the judgment amount. You'll get that also, but it's not part of the judgment.
Right. And then $315, I was not added in that original amount that I filed for 1850. The 1850 does include the $40.
Well, I have
Reason-
1935
Right,
plus
1935
40 is 2000 or what is it? It's 1975, but you have
Right.
1850. So what?
The reason is because he on a different invoice he fixed a light, and so I felt I needed to pay for that,
Okay.
even though he did fix that. So that I adjusted the invoice for him fixing the light, and so we're back to the 1935, and then 315 for work that he did not complete as well.
So
And that
really
was
it's the
painting.
1850 plus the 315.
Yes.
Okay. So that
Yes.
comes out to 2165. Is that correct?
That's 1850 and the 315, 16, 2165.
That's what I came up with. Yes.
Yes, sir. And that does not include the court fees.
Yeah. Again, that's separate.
Yes, sir.
All right. So I will grant judgment in amount of $2,165 plus court costs.
Thank you so much. I appreciate that. And then I will look into the file abatement process
Yes.
and the other thing we spoke of.
All right. Thank you, ma'am. Have a good day.
Thank you. You too.
So, Mr. Maldonado, you're here, and you are being sued for a vehicle accident. And Ms. Hymes is claiming that you're at fault on this. You did not file an answer, but you have appeared here today. And so I will take your appearance as your answer as a general denial, but you still need to file one. Do you understand that, sir?
Yeah, that's the problem. I didn't know how to like I've never done this, so I thought, like me, this is like kind of like, the process. So,
Well, what you need to do is you need to call the court here or go online. We have a website, and under forms, you can look for general denial. That's the form you're looking for that you need to file. We are going to, like I said, I'm going to accept your appearance here today as an entry of that general denial, but you still need to put it in writing so that we have it. Make sure you send a copy of Ms. Hymes. If you don't have information, just make sure it gets here, Ms. Hymes, just so you understand. If you want, you can share an email address with him. Just send it on the little chat button down below there. And just do it privately because we're on live right now. And so what's going to happen is we're going to schedule a trial setting. And any information that you all need to exchange or any negotiating that you all need to do it between today and the day that your trial is set. Do you understand that?
Yes, Your Honor.
And then if you reach an agreement, then I would suggest you memorialize it in writing and then come back on the day of the trial and let us know what you have, and then we'll go from there. Or we'll just see you on that date, and then at that point in time, we'll have a trial, okay? Make sure your witnesses are here, any evidence you want to present, that you've either filed it or you have it available for us to look at.
Okay, Your Honor. I had a
Any
quick question, Your Honor.
Yes.
I do have a witness. Would you need him to come on the day of the trial?
That's when he needs to come, right?
Okay,
Right.
perfect.
If he has evidence that he witnessed the accident, then he has to testify as to what he saw,
Okay,
okay?
okay, thank you, Your Honor.
All right.
I had one last question. If we were to come to an agreement, let's say if he agrees to pay, do I have to show back up to court, or do I have to go to the Travis County Clerk and tell them that we came to an agreement?
Well, there's a number of things you need to do. I cannot give you any advice here today, but if you guys reach an agreement, right, you have to decide if you're going to go ahead and dismiss the case now, or you're going to put the case on hold temporarily to allow him to pay for that. Or if you're going to write down your agreement, or if you're going to say, you know what, we want to go ahead and get a judgment, I'm going to hold on to it to allow him to make the payments or do whatever he's going to do. And if he doesn't, then I'll file the agreement. In other words, you see, there's a lot of options that you can pursue under the circumstances. That's what I can't tell you what's best for you, but those are things that can be done. So it can either be dismissed right away or it can be, postponed. But I can tell you this, if you don't communicate with the court what you're doing and you don't show up, the case will be dismissed.
Okay, Your Honor, thank you.
All right. Mr. Maldonado, any questions?
no questions. I mean, that's the only thing, I didn't know. It's like my first time getting, having to come to court for for something like this. Mostly like the few times that I've been to court has only been for like tickets, like, like some speeding tickets, and I'll be honest, that's pretty much it. It's the first time I'm getting sued, so I was just like, I didn't know what was the process, and I didn't really like have like the chance to be able to like, kind of like look into like all that because of work. And then right now I'm kind of like, stepping out of my 9 to 5 because I'm losing hours, and I'm not making that much money. So, and also because I tried to also like kind of like text back or like answer back to Sarai, and she never responded back. So I took that as okay, then let's go to court, or like I'll be here for the Zoom. So
All right. This can be a daunting process. If you have any questions on things you need to file, you can call the court. They cannot give you any advice.
Yeah.
Okay, but if you're saying, well, I need the general denial, well, call the court and they will email it to you. Something as simple as that. They can do that. Or you can go online and look it up where it says forms and just look for the one that says general denial. Just get it yourself. Everything else is up to the two of you to reach an agreement or to decide how you're going forward. Okay.
perfect.
Yes, Your Honor.
Thank you both. Have a good day.
Thank
too.
you.
Bye.
Too.
Thank
Bye.
you.